Hi everyone, I just wanted to discuss this case of ITC Limited versus Central Park Estates Private Limited and another. This case is an attempt by ITC to safeguard its trademark Bukhara against the use of bulk Bukhara by Central Park. I will be going through the facts of this case and the arguments followed by judgment that was given by the Delhi High Court in 2022 by Justice Pratibha Singh. Also, this case has highlighted the position that was taken in the United States while dealing with the dispute between ITC and Panchgini on similar lines, which will draw distinction between the applicability of well-known marks principle in US and India. So in this case, ITC is the plaintiff, which is seeking protection for its trademark Bukhara, used in respect of restaurant and other hospitality services. Plaintiff had commenced its hospitality business in the year of 1975, and it had several hotels across the world. It had adopted the trademark of Bukhara in the year of late 1970s, and it was used in ITC Maurya Hotel in Chanakyapuri. It is very famous for its interiors, decor, layout, arrangement of the restaurant, the cutlery in which the food is served, the wooden menu card, and the rustic look which it has maintained over the years. So these are certain aspects which are used in its restaurant for which people identify it to be that of Bukhara, right? And then they have stated how Bukhara is very famous amongst the people, like many renowned celebrities, presidents, and head of states have come there to try food at Bukhara. Their food has become globally acclaimed by food critics, and it also has a website that is maintained online, and it has earned about 20 crores in the last financial year. It is registered in India since 1985 in both word form and in logo form. Here they have given the details of the trademark registration that is done. Plaintiff has also shown its unique decor and stylized font that is used, and it has mentioned that it has won numerous awards in the past few years, and as a result of this, they are claiming that they have acquired the status of a well-known trademark. In contrast, they are highlighting that the defendant is infringing their trademark by using the mark Bulk Bukhara and Bulk Bukhara restaurant, which they have applied for registration, right? So it has obtained registration with the objective that it is proposed to be used, and defendant has imitated all the special features such as the name, logo, font, interiors, decor, seating style, staff uniform, bib, apron that earlier ITC claimed is unique to it, and the clients or the customers that come there associated with that to be of Bukhara by ITC. And here they have shown that this is the trademark being used by plaintiff. This one is on the right being used by the infringing party, that is the defendant. How the aprons look, the mat look, napkin look, the uniform of the people who are serving the food, the trays, seating arrangement, and everything is also shown. So, as per this, plaintiff has sought a decree of permanent injunction to restrain the defendant from manufacturing, selling, offering for sale, advertising directly or indirectly using the trade name Bukhara, or to indulge into passing off. They have also sought to declare their iconic trademark of Bukhara as a well-known mark, and they have sought for rendition of account of profits. They are claiming damages to the tune of 2 crores, and simultaneous suits are also going on for them to be claiming that the way they write Bukhara is an artistic work, and they have also filed for cancellation of the two trademarks that have been obtained by the defendant, and they are also claiming for rectification of the mark based on section 57. By the time this judgment was given, the parties had amicably come at a resolution where defendant said that it will not use the word bulk Bukhara or Bukhara in any manner. The injunction was granted, and as a result, defendant also agreed that it will change the look of its menu, jacket, and uniform of the person, the utensils they are using, or they'll remove the word Bukhara from its display board, promotional items, website, napkins, menu card, and everywhere. And also, defendant has agreed for the mark to be rectified or cancelled. Next comes the question of whether Bukhara is a well-known mark, and this becomes very important, and we'll see how well-known mark is seen from US perspective also. I find this judgment highly important because it traces down all the well-known marks cases that have happened and formed the jurisprudence in India. So section 2 ZG tells what a well-known marks is. It is a trademark in relation to any goods or services which has become so to the substantial segment of the public. So substantial segment is the one who is actually dealing with the good, not to everybody in the country that the mark has to be known, but substantial segment of the public which uses such goods or services, such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to the first mentioned good or services. It basically says in simple words that if there is this brand called Bata that is a footwear brand, and there is this another brand which starts selling mattresses in the name of Bata, then likely the people who are going to the market and see both Bata would assume that Bata is coming up with a new business of mattresses. So this cannot be allowed because it rides on the reputation of Bata or any other brand for that matter, and this is an actual case named Bata India Limited versus Pyarelal. So you cannot allow somebody else to ride on the reputation. There is another case which is very famous, which is Daimler Benz versus Haibo Hindustan, as we'll see in the coming paragraphs, which highlights that you all know Mercedes Benz is a very famous name for automobile. However, there was a person in India who started using Benz word for his undergarments that are being sold, and Mercedes Benz initiated an action against this person, claiming that their mark is a well-known mark and the defendant should be refrained from using the mark which was allowed, right? So section 11 clause 2 of the act tells us that section 11 basically deals with relative grounds of refusal. This is that if such a situation arises, then your trademark might not be registered. So the situation 11.2 talks about is that you are using an identical or similar trademark for dissimilar goods and services, like we discussed in the case of Bata versus Pyarelal, where they're using identical or similar trademark but the underlying goods and services are different, right? Footwear versus mattresses, then you will not get a trademark protection. And next 11.6 tells us the factors that have to be considered by the registrar to declare a mark as well-known marks, and it allows him to consider any such factor that he deems relevant to determine whether mark is well-known or not. But there are 5 things that are mentioned in the provision. The first is knowledge or recognition of that trademark in the relevant section of the public. Again, the clause used is relevant section of the public should know. And it could be through promotion also. Like, it's not necessary that the goods or services are available in India, but that through promotion the people in India are aware. Next, clause 2 tells about the duration, extent, and geographical area of any use of that trademark. Next is duration, extent, and geographical area of promotion of that mark, or duration and geographical area of registration of that mark, or any successful enforcement of their trademark as a well-known trademark by any court or registrar will allow their mark to be counted as a well-known mark, right? Then section 29 deals with infringement, and 29 clause 4 tells that protects well-known marks against dilution and unfair advantage. So it says that a registered trademark is infringed if another person is not a registered proprietor or is using a mark without permission from the registered owner in a manner that he's using identical or similar trademark, and the underlying goods or services are not similar, and this particular registered trademark has a reputation in India without and the registered trademark has a reputation in India, and the use of this mark without due cause takes unfair advantage of or is detrimental to the distinctive character repute of the registered trademark, then it cannot be allowed. It will amount to infringement. So then we are tracing down the Indian jurisprudence, which has widely recognized even transboundary reputation of foreign marks and accorded them the status of well-known marks under common law. What it is trying to highlight is that in India, well-known status of goods are recognized even if the goods are not used in India, but they are famous outside, right? So first case was Apple Computer versus Apple Leasing and Industry, where Apple, you all know, is gadget based company. It's for personal computers, and in India a person was using the name Apple for leasing and providing computer education. This is a 1991 case, and in this case Apple's right was recognized, saying, I think that the plaintiff have a good prima facie case and the balance of convenience is also in favor of the plaintiff for restraining the defendants from using the words Apple. Next is the case of Daimler Benz versus Hybo Hindustan, which I've already told you. Benz right was upheld by the court. Then is the very famous case of N.R. Dongre versus Whirlpool Corporation in the year 1995, whereby the mark Whirlpool belonging to a US company was recognized as well known despite the mark's registration having lapsed in India. So you don't even need to have your mark registered in India, and India will grant you protection. It noted that the trademark Whirlpool has acquired reputation and goodwill in this country, and the same has become associated in the minds of the public or potential buyers with the goods of the first respondent. So we note that India has a very rich history of recognition of well-known marks, especially foreign marks, even in relation to completely unrelated goods and services. We are seeing in the case of 2017, that is Toyota versus Prius, that Supreme Court had taken a little stricter interpretation of the law, wherein it noted that it again reiterated on the principle that real market for the foreign good is not necessary. However, presence of the plaintiff through its mark within India in a more subtle form is required. Since there was no evidence of use or even advertisement of the said mark in India prior to the defendant's use of the mark in 2001, injunction was denied. So it does not mean you are completely not present in India, but you are still claiming protection. That will not be given protection. So coming back to the Bukhara case, we are noting that many celebrities are aware of it. It is covered in the newspaper, heavily advertised. It has world famous cuisines that has won multiple awards. Many of the star chefs around the world have worked at Bukhara before, and there is a similar dispute that was going on in the US, wherein Bukhara had opened a branch in US, but it had closed down after a period of 10 years. But the ex-employed opened another entity called Panchkini and started the business with the name of Bukhara Grill. So this entity, which is now only based in India and other places, not in US, claimed infringement of its trademark in US. However, US denied them this protection, saying that you don't have any presence in India, you don't have a goodwill or reputation in India, so you cannot get this protection here. Also, it said that well-known mark status is recognized in TRIPS, and it said that TRIPS is not automatically read down in the US legislation unless any federal law is in place, which is not in place as per them under the Lanham Act, and hence the protection was denied to ITC in this case. However, in this judgment by Delhi High Court recognized that Bukhara has originated in India and enjoys substantial goodwill and reputation, not only among Indians but also among foreigners who travel to India and carry back the said reputation. Hence, as also India recognizes trans-border reputation and the well-known mark doctrine, both in its judicial decisions and its statutes, Bukhara of the plaintiff was declared as a well-known mark. There's a very good research paper I had read which showed the duality of US interpretation while dealing with protection of foreign well known marks in the US compared to seeking protection of US well known marks abroad. Like, US had a very famous case in China for safeguarding its right of Tesla. So it is very forward. However, when companies such as ITC go to US to get its well-known mark protected, they deny it, saying that it is not recognized under their act. So we'll discuss it in the next video or sometime later. Thank you.